The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. We'll jump right into our first case today, Crosby versus Colleton County Sheriff's Office.
Morning, Your Honor. May it please the court. My name is Nick Charles. I represent the plaintiff and appellant in this case, the estate of Jerry Crosby. This case arises from a situation that is important in our country today and seems to become more important by the day if you follow the news. And that's the collision that occurs when police conduct welfare checks, the collision between law enforcement activities and the most sacred and protected Fourth Amendment rights that we have, which is the right to be secure in your home and free of governmental intrusion. In this case, and I'll be...
in this case, this is a wellness check, something different. We use the Graham factor to evaluate the officer's conduct?
For the use of force itself, yes, but importantly, it's the totality of the circumstances, which includes a consideration of the officer's unreasonable conduct that leads up to the use of force. In this case, when Officer Scott, I'll be very brief on the facts, I know the court knows them, but Officer Scott was dispatched to conduct a welfare check based on a call from Jerry's wife that said that a couple hours earlier he had said that he would harm himself. And when Officer Scott arrived on the scene, he found a scene that, whether you view the components of it in a totality or in isolation, would not lead any reasonable person to believe that something was wrong. Certainly not that there was an emergency.
Really?
Yes, Your Honor.
Given the phone call? Because I can definitely, I mean, having watched this entire video, I can definitely see how a person who received a report of that welfare check and arrived to find what this officer found might very much suspect that something was wrong.
Based on this court's precedent and then the Case v. Montana case, the one that this court rescheduled this oral argument to wait on, the precedents are that a 911 call alone is not enough. And arriving at the scene, the officers need to see some kind of objective and affirmative signs of an emergency. And what this officer saw was a dog barking, a truck in the driveway. This is a rural...
Absolutely no response to repeated knocks and announces?
Correct.
None. Not go away, not I don't want to talk to you. Absolutely no response.
Which is Jerry's constitutional right to ignore the police. He doesn't have to come to the door. He's entitled to leave his doors unlocked.
Sure, but I understand a person is allowed to do that as a matter of the Fourth Amendment. I just don't think it's reasonable to say that as a reasonable officer knows that the overwhelming majority of times that people are there, they at least say something. Doesn't every reasonable police officer know that?
That might be something that they normally...
Like, go away, including go away or get off my property. But what's very, very, I suspect, unusual in a situation like this is that the person says nothing at all.
I doubt that that's that unusual, Your Honor. I mean, yes, people probably often come
What about hushing your dog, right?
Sorry?
What about hushing your dog? If you're at home and your dog's barking, if you're awake and conscious, it's probably going to annoy you, right? And you'll say, hush up, Sparky, right? There's nothing. And it may not be suspicious without the call, right? But once you have the call, do we want the officer to check on this man?
Check on him, yes. Not enter the house without a warrant. And to answer the question about the dog, some people hush their dogs, some don't. I mean, my dog barks at the neighbors when they're in their garage across the street. If
your dog barks, I suspect, a little bit, once, twice, 5 seconds, 30 seconds. I suspect your dog doesn't bark for minutes without you hushing them.
Unfortunately, I wish I could say the answer was different.
Without you even try. No, look, I understand you might try to hush them and you might fail, but I suspect that your dog does not bark for minutes at a time with no effort to hush them.
I don't want to get too far outside the record into my personal experience with my own dog, but it depends on what he's barking at. If he's barking at a person prowling around the outside of my house, shining a flashlight in the windows, then I'm going to let him bark. If he's barking at my neighbors who are mowing their yard across the street, then I am going to hush him. And
Well,
here,
You've had 15 minutes, and we've been talking about exigent circumstance. You're not gonna win on that, even with me. Talk about the shooting. That's what's important in this case.
okay. Your Honor, the shooting, as we know, it's evaluated by the totality of the circumstances. The Barnes versus Felix case from the U.S. Supreme Court that came out last year emphasizes that it's not a moment of force analysis, it's the totality of the circumstances, including a consideration of what led up to that, to the use of force.
Let me ask you in that regard. I mean, it seems to me like it boils down to that gun and what he said. Just before he shot, the officer said something, don't. What does he say? Don't pick up the gun, don't point the gun, don't shoot me. Does the record say, give us any answer to any one of those questions?
I'm sorry, Your Honor.
Does the record give you any answer to any one of those three things? Don't pick up the gun, don't point it, or don't shoot me.
That is not what Officer Scott said. He said, no, don't, as Jerry is walking
He is
across the
walking
bedroom.
deliberately and calmly while staring at the officer to get a gun.
He's walking deliberately and calmly across the bedroom.
I just feel like, I mean, this case is horrendous in so many respects, but I don't understand how you can tell a police officer that you have to watch a person calmly and deliberately ignore your commands to stop as they go over and retrieve a firearm. I don't understand how a reasonable officer can possibly be, much less how it would be objectively unreasonable in violation of the Fourth Amendment, and so objectively reasonable in violation of the Fourth Amendment as to deprive qualified immunity that you have to let a person calmly and deliberately while staring at you go over and retrieve a gun.
Yes, Your Honor. The precedents are that commands have to be clear. No, don't is not a clear
Doesn't our
command.
precedent also say that officers are reasonable to think that a person who greets the police with a firearm doesn't have a right to do so, right?
That is a
That
line.
person poses a danger to the officer?
That is a line, I think it was in either the Elliott or the Stanton case. But the other cases that we cited in our brief, like Nibbs and Benton and Cooper.
Those are all
and-
cases where a person maybe didn't know that the officer was police, right? There was a person, but they didn't realize a police officer was at their door. They didn't realize officers were out there, right? There were questions along those lines. Here, none of that's in dispute.
Well, I mean, one of those cases, I think it was Nibbs, the court acknowledged that anyone can say that they're a police officer. In this case, Officer Scott stalked down the dark hallway with his gun drawn with a powerful flashlight into a dark room, stood in the doorway, and no matter how many times Jerry said, "I'm fine, get out of my house," Officer Scott said, "I won't."
But in response, okay, this is a welfare check. And the officer says, I don't know if this is an exact quote, but he says something like, "Did you take anything?" Which feels like a highly germane question when conducting a welfare check, particularly given what the officer had found outside. I mean, particularly given what the officer had found outside. And on the video, the decedent does not respond to the question, "Did you take anything?" The decedent just says, "Get out again." So in response to the officer's direct question, which is directly germane to the reason the officer is there, the decedent gives a non-answer. Why isn't a reasonable officer allowed to be very concerned about that fact? I can't finish the welfare check until you answer the question, "Did you take anything?"
The officer didn't have, well, obviously my position is that the officer didn't have a reasonable basis to be in the house in the first place.
Yeah.
And that nothing he saw outside nor anything that he saw inside gave him a lawful right to be where he was. Now, at that point, when Jerry says, "I'm fine, get out of my home," any purported emergency, a reasonable officer should deem that any purported emergency is over.
What if
And-
sorry, I'm not sure that's at all true. What if he had taken a fatal substance?
Well, as a matter of fact,
A person
he
who,
hadn't.
a person who has ingested a fatal substance has a legally protected right by the Fourth Amendment to order the officer out of their house so that they can die alone in peace in their house. I mean, I'm just not aware of any proposition of the Fourth Amendment that says. So you said once he says I'm fine, the officer is required to simply accept his word for it and leave. And I am not sure what principle of the Fourth Amendment says that.
It also, Your Honor, goes into the reasonableness of the use of force, though. And Jerry says, I'm fine, get out of my home, numerous times. He then gets up, calmly walks toward the closet, and in the face of unclear commands, he picks up a gun. At that point, when he's asked the police to leave numerous times, and the police officer refuses to leave, and Jerry can't see him, and he's wearing what is not a normal, he's not wearing a blue police uniform, he's not dressed like the deputies downstairs. He is wearing tan pants and a black shirt, and
But
that's
He's
it.
wearing a police, that's a police uniform. It has a badge, it says it's police.
It's a
not
black
blue,
shirt.
it's tan and black. We'll
It says
grant you
sheriff
that.
in on a tiny patch in
Right.
dark
What do you
letters.
say about Judge Gergel's remark that there's just no evidence whatsoever in this record that the decedent, there is no evidence in this record to create a genuine dispute of material fact about whether the officer should have believed that the decedent might not have realized he was a police officer. I think I've correctly stated the Fourth Amendment question. Judge Gergel just says there's literally nothing that would support that finding, that a reasonable officer should have known maybe he didn't realize I was a police officer.
When he's standing there in the doorway, having unlawfully entered the house and having
Whether
been ordered out,
he's lawfully or unlawfully entered the house has nothing to do with whether the officer should have realized that the decedent might not realize he's a police officer. That might be why the decedent would be very angry, but not. That doesn't bear out in any way on the question of whether there's a dispute about whether he realized he was a police officer, which is what I'm asking you about.
I believe it does, Your Honor. He is
Mr.
saying,
Charles, I want you to focus on the case law says it's a furtive and threatening move.
correct.
And I assume that everybody's relying on the video. And that's the reason I asked you a while ago, where it looks to me that video like it's a handle, it's not not the barrel of the gun. I can't see the barrel in it.
Correct.
So I don't know, to me, there's a reasonable question of fact that the jury can decide, did he make a furtive move? I don't think so. And was he threatening? It's his home. He goes and reaches for something, and it looks like a wooden stock. It doesn't look like a gun. Is there any evidence that shows that that gun was pointed in any threatening manner toward that officer?
No, Your Honor.
So why doesn't the current case law protect you in terms of getting a trial by jury in this case?
It does. He did not make a furtive movement. He did not make a threatening
So you
movement.
think getting out of bed, crossing the room to retrieve a gun was not a furtive movement?
Getting up and walking calmly and deliberately across the room
To get a
is
gun.
not a furtive movement. Reaching into the closet and picking up a gun, keeping it pointed at the ground, is also not
Where
a
in our
furtive
case law does it
movement.
say that you have to point the gun at the officer before the officer has authority to shoot?
It doesn't. It is aimed at or a furtive movement.
Mm-hmm.
And he did not make, a reasonable jury could conclude that he did not make a furtive movement when, much like Nibs, the case where the person racked a shotgun, Benton, the case where the police charged in and the guy came running out and pulled out a gun. In those scenarios, and I think the Cooper case too, in those scenarios, the court considered whether a reasonable jury could find that the officer shouldn't have been threatened by a person who, in his own home, picks up and holds a gun but does not aim it at the officer. And that's the situation that we have here.
And in Nibs, the person was in their own home and the officer was outside, right?
Correct.
In the dark. And so you're saying that's the same, that the Constitution requires, officer comes in, says, I am a police officer. Person says, oh yeah, gets up, goes and gets the gun. At what point does the Constitution say the officer is right to fear for his life?
When
When the gun's like 90 degrees, 45 degrees, how much does it have to be pointing at him?
That's for a jury to decide whether
Is
the
it?
officer should have been, yes, it is, whether a reasonable officer would have been threatened
Because
by
our
those
clearly
movements.
established case law seems to say that an officer doesn't have to wait for it to be pointed at him.
The officer may not have to wait for it to be pointed at him, but a jury has to determine whether it's reasonable for an officer to conclude based on the movements that he sees, whether he feels threatened and thus deadly force
Do you think a
is
reasonable
justified.
person would not feel threatened if someone greeted them by going across the room to retrieve a gun?
I think a reasonable jury could find that the
That's not a
officer.
threatening thing to do.
Correct, yes, Your Honor. After he calmly and deliberately walked over there, he didn't run over there, he didn't.
Would running make the difference? Is that where we should draw the line in our case law? If he ran to get the gun versus if he walked to get the gun?
It could make a difference to a reasonable jury viewing these facts. And importantly, I know that I'm out of time, but the facts have to be construed in the light most favorable to the plaintiff.
We have a video,
at this
right?
case.
We could
Correct.
look at the video, and if there's any doubt, we can construe it in your favor.
And the video doesn't show him pointing the gun. It shows him picking it up, and it's pointed at the ground, and then the officer fires. And I apologize for going a few seconds over, but I ask the court to reverse the district court's ruling.
We'll hear from Mr. Griffith.
May it please the court, Mitch Griffith on behalf of the appellees, Colleton County Sheriff's Office, Officer Jake Scott, and Buddy Hill, Sheriff of Colleton County. If a picture's worth 1,000 words, the video shows the whole story in this case. The video's clear, and I'd submit to you that there's very little to debate on the facts. It's all on the video, as the court has seen.
Well,
And
tell me if it's so clear, where do you see a barrel on that gun? When he goes to pull that wooden stock out of somewhere, where's the barrel?
yes, sir.
And
I
show me.
believe
mean,
there-
I'm willing to be corrected about that.
Yes, sir. And if you look in the record, the SLED report and Officer Scott said he leveled the gun, meaning he was bringing it up at the time that he was coming across when Officer Scott was backing down the hallway yelling, no, 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 don't.
But the video works up until 2 seconds before that pistol was fired, so what am I missing?
But, Judge, the video works through it, and we see the gentleman walks across, Mr. Crosby walks across his room. At that point in time, he fails to acknowledge the commands of no, 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 don't. Officer Scott had indicated in his deposition that he thought he had a gun as he was laying in the bed. However, when he gets up, goes across the room to a closet, and then comes from behind the door, he's got what Officer Scott identifies as a gun. Now, does the officer have to wait for him to actually have the gun pointed at him, finger on the trigger? I don't think that's what the law says, and I don't think that's what the Fourth Amendment says. It's reasonable. He had a reasonable belief that he was in danger. If he didn't, he certainly wouldn't have been backing back up. He was looking for some place to get away from him. He took what action was reasonable under those circumstances, and he doesn't have to wait for Mr. Crosby to have his finger on the trigger, ready to shoot him.
I'm not terribly hot about this particular argument, but, and I think I told Mr. Conn, I don't think he can win on this, but the argument is this. His affect is he looks to be reasonably clear-eyed. He's not wobbling around. He walked, he's standing up, he says, I'm fine. He tells that officer 8 times, get out of my house. When does exigent circumstances stop?
When does exigent circumstances stop under that situation?
Yeah, when should the officer turn around and walk out?
In this situation, Officer Scott indicated that he had seen a suicide note, he had seen pills, he had seen what appeared to be a glass turned over and his phone down on the floor. Indications that a reasonable officer would have an objectively reasonable belief that exigent circumstances existed. He goes in the house. He walks down the hall. He identifies himself as Sheriff's Office. Now, he's been called in the appellant's brief a nocturnal trespasser. However, at that time, the first comment from Mr. Crosby was, "What can I do for you?" Not what you would understand a trespasser, what you would probably say to a trespasser. Your first comment is, "Get out of my house." Now, when you ask, where does exigent circumstances end? If we look at Montana, Montana says at the end of the opinion, we don't have to let someone to wait on their own fate, walk away and leave them to their own fate. I don't think that exigent circumstances really ever ended in this case. If the man's trying to commit suicide, which we've got all the factors that show an objectively reasonable belief that he may be, and he says, "Get out of my house," is he still contemplating suicide? If you listen to the video, actually, if you close your eyes and listen to it, his voice changes when Deputy Officer Scott says, "I'm here to check on you." At that point in time, you can actually hear the inflection of his voice change. Is he planning on continuing to commit suicide? Should the officer turn around and walk out? That's exactly what Case versus Montana says. No, we don't leave them to their fate. We're there to check on them. He said, "Let's go downstairs and talk about it." He wanted to get him outside. He had, I believe, at that point, excuse me, at that point in time, animal control was still coming, although they had taken care of that situation. But in addition to that, they had other officers coming to check on him. They wanted to make sure, maybe a professional to look at him and say, the EMS to say that he's not on any kind of alcohol. While you say he walked across, Deputy Scott says he sounded like he was slurring a little, slurring a little bit. As such, he's still trying to, in the situation, that he has actually an emergency aid and wants to have a professional look at him. I don't think in this case, emergency aid ever ended in this case. Even though he said, "Get out of my house," it already had the conversation. Now, while I would speak to the elements of emergency aid, it does appear that all the factors meet to have the officer have a reasonable belief that emergency aid exists. We've also got the fact that as we talk about the excessive force case, I think, as Judge Rushing said, we don't have to wait for the gun to be drawn down on us under the Fourth Amendment. We only have to be reasonable. And in this situation, it was obviously reasonable for the officer to think that he was about to be shot. And as a result, he met force with force. We think the case law supports this, and the video in this case supports the facts that he came out. I think actually having a gun pointed at him is probably a distinction without a difference in this case. As to the issue of qualified immunity, obviously qualified immunity, the district court found that there was no violation of the Constitution. As a result, there was no need to go into the qualified immunity, into the second prong of the qualified immunity step. As such, the law, as well as the facts in the video in this case, show what Officer Scott did was reasonable on that day in entering the home with exigent circumstances, as well as with his actions with respect to the force that he felt, that he believed was deadly to him.
Where did he say that? Where in this record did he say that to the EMS people, SLED, or anybody else? Where did he say that?
And he didn't say SLED was coming, no, sir. He said that he had emergency, I believe he said, excuse me. He said that he had someone coming, I believe an ambulance was coming also. And Judge, I can't point to the record right now where that is, but I believe there is no indication of SLED coming. I think it was the ambulance.
My question is, what did he tell the EMS folks? He didn't say my life was threatened, I was in danger, he didn't say anything like that.
Well, when he finally got in touch with the EMS was on the way. I think he said, if I'm not mistaken, expedite, when he was down in the porch. And he told Officer Cummings to step outside so that you can communicate. And this is an area that is way off the beaten path, pretty much, in Colleton County. It's out on the river. It is actually visible from a main road, but it's sort of strange to get there. So he had Officer Cummings outside, and I believe that when he was on the porch, Judge Floyd, he said, expedite. Now, with that, I go back to the issue of qualified immunity, and in this case, obviously, Judge Gergel found that where a warrant is not necessary, exigent circumstances existed. There's no constitutional violation. He also found that when you have an exchange with a person laying in bed, he gets up, walks across his room, gets a firearm, ignores the commands to stop, 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 no, don't, then pulls the gun up, and at that point in time, Officer Scott had a reasonable belief that his life was in danger. As such, there's no constitutional violation, and as a result, we think that the evidence shows in this case that that Officer Scott was very reasonable in his approach to the house. He checked the car, listened for noises in the house. There was no response. He kept trying to get a response. He honored the sanctity of the home when he used constraint and restraint before going into the house. And when he sees the suicide pills and the phone on the floor, he has reasonable exigent circumstances. As such, the Fourth Amendment protects officers and protects from unreasonable invasions of the home, unreasonable use of force. And in this sense, the video shows that in every sense of the word, Officer Scott was reasonable in this case. If there are any other questions.
Can I ask you about Monell liability? If we, there's two prongs to the qualified immunity analysis, and if we ruled on clearly established prong, but not on the constitutionality question, prong one, there might still be a Monell question, right? Is there any evidence of a pattern that was submitted in this case? Did the plaintiff present any evidence of a pattern of similar
No, ma'am.
events, similar violations in other circumstances?
No, ma'am. Not from the Colleton County Sheriff's Department, not from Officer Scott having anything in his background. I think they did fill the record with an issue he had when he was with the Beaufort County Sheriff's Department, which there was no finding of any probable cause to bring that against him. So there's no pattern here. And as such, first of all, since his actions were all constitutional, we don't even have to get to the second prong. But to get to the second prong, I think there is no pattern here that there's anything to establish that Colleton County Sheriff's Department did anything that would have been, that would have raised an issue with regards to Monell.
And there was evidence that the sheriff's office trains officers on Fourth Amendment issues, right?
They do train officers on Fourth Amendment issues. Their Fourth Amendment issues are within their policies and procedures. They even talk about, I don't think that exigent circumstances were probably as developed as we had with Case, and I think maybe Calignia came out right around the time that this actually happened. So no, ma'am.
Okay, thank you.
Anything else? I appreciate your time. Thank you.
Mr. Charles, you have some time on rebuttal.
Yes, thank you, Your Honor.
Mr. Charles, before you get started, I have a question I'd like you to address at some point during your rebuttal. I don't care if you do it right away, but I want to say it. So, can you just help me understand, as a matter of the Fourth Amendment, why I understand why a furtive movement might be threatening. I don't necessarily understand why a furtive movement would be categorically more threatening than a slow and deliberate movement, because in some ways I can imagine a world in which there's nothing as terrifying in the world as someone slowly and deliberately doing something that you perceive as threatening. So if at some point you could just address my intuition that I'm not sure why for the Fourth Amendment, the fact that it was slow and deliberate rather than sudden and furtive categorically makes it less threatening.
If it's okay with Your Honor, I'll try.
Absolutely.
To
No,
think about
I just
that
want you to address
while
at some point. I don't care what.
Judge Floyd, to answer your question of Mr. Griffith, Officer Scott did not call EMS until after he shot Jerry Crosby. When he arrived on scene and he first starts searching the property, he called for animal control because we need to secure this dog so we can clear the house. So that was before he had entered the house at all. That was after he had knocked on the door. He'd already decided we need to clear this house, and so he called animal control. At that point, he hadn't even seen anything amiss yet, but I know it's an objective test, but what happened and what he thought does matter for what the consideration of what a reasonable officer would on the scene would believe. After he entered the screen room and he found what he interpreted as a suicide note, and he found the pills, he got on the radio and he said, expedite animal control, and who is the on-call CID? CID is the Criminal Investigations Division. So when he saw the pills and he claims that he thought that a suicidal overdose was in progress, he called the dog catcher and the homicide detective. He didn't call EMS, he didn't call anybody to come help if, in fact, an overdose was going on. When he walked up into the hallway and he called out sheriff's office and Jerry replied, "What can I do for you?" Well, that language is also not the language of a person who is in the process of committing suicide. And all of those factors play into the totality of the circumstances and the reasonableness of Officer Scott's conduct as he approached the room and escalated the situation into what ultimately became him using deadly force against Jerry. On the factual point about whether Officer Scott thought that Jerry had a gun in the bed, there's no evidence in the record that would support that belief. That appears to have been a hunch, but they didn't find the gun in Jerry's pocket until at autopsy days later. It was never visible in the room. No one even on the scene giving emergency aid to Jerry after he'd been shot found that.
But you're right that it's an objective test, right? So there's no reason to think he had a gun in the bed with him, even though he did. Similarly, he'd gone behind the door and retrieved something that looked like a firearm but wasn't a firearm. But an objective officer could believe that his life was being threatened, right? Even if it wasn't a gun. We have plenty of case law like that, don't we?
We have some case law like that in different factual contexts, but again, it is a question for the jury whether a reasonable officer would perceive his slow and deliberate movements, which I know I need to address, as being a threat, an immediate threat that required the immediate use of deadly force. The furtive movements, the answer to the question, I believe, is that it just impacts the reasonableness of an officer's actions. A sudden furtive movement is more threatening than a slow and deliberate.
I'm just not sure why
movement.
that's a categorically true statement as a matter of the Fourth Amendment. I could imagine situations in which there is nothing more terrifying to me in the world. Like, let's say that I know that there's a gun, on that table, and you start walking towards it, and I tell you to stop. And you do not stop, you do not speed up, you do not slow down, you keep walking. I tell you not to, and you keep doing it. I don't actually know why. The fact that you're completely ignoring my increasingly fervent commands that you stop what you're doing and yet continue doing it anyway, that almost to me seems more threatening. Because now I know that you hear me and you're disregarding it.
You wouldn't have the right to shoot me right then, though.
But I don't have to wait till you have the gun pointing. I quite assure you that I do not have to wait till you have the gun pointing at me if you slowly and deliberately walk towards what you and I both know is a gun over there.
You don't have to wait until it is literally pointed at you.
Do I have to wait till it's in
Right.
your hand?
I believe so, yes.
A police officer has to wait until a suspect picks up the gun that the officer has ordered the suspect not to pick up. You have to wait until they've physically picked up the gun.
I don't think a police officer can shoot an unarmed man who.
What if
has not
their hand is 2 inches away from the gun? Can you shoot them then?
That goes back again to the question that the jury has to decide at what point would a reasonable officer have felt threatened by the movements.
Why does a jury decide? We were talking about qualified immunity, right? The question is not like whether any jury could hypothetically find that it was not reasonable. The question is it clearly established that it was unreasonable?
That's one prong, and I'm arguing
Yeah,
about the
but there's two
constitutional
prongs.
violation.
There's two prongs.
And I'm
You
seeing
can
that
lose on either one.
I'm out of time, Your Honor. Could I address the Monell question that you asked
Oh, sure.
Mr. Griffith briefly? That is an important point because, as Your Honor said, if you find that it's not clearly established, but you find that there is a constitutional violation, the Monell claim can survive. And the evidence here is that that the Colleton County Sheriff's Office provided no training of any kind to its deputies on welfare checks, how to conduct a welfare check, or the emergency aid exception to the warrant requirement. And the evidence is also that the Colleton County Sheriff's Office conducts 500 to 600 welfare checks a year. This scenario is very similar to the hypothetical that the Supreme Court posed in the City of Canton case about officers using deadly force or being armed to chase felons without having any training. It is a moral certainty that Colleton County Sheriff's deputies will come into this scenario in which they collide with a person's Fourth Amendment rights in the home, and they provide
But they
no
do
training.
provide training on when you can enter a home and under what circumstances, right? It's kind of a question of specificity. At what point does the Supreme Court's precedent on that, or not even precedent, hypothetical on that point kick in?
They
Yes.
provide no training on the Fourth Amendment that would guide them on a welfare check. I mean, the Fourth Amendment training that they received is like hot pursuit. It's all in a criminal context. They have no training whatsoever.
But it's about entering the home, when you're allowed to enter a home and when you're not, and how you conduct yourself there.
It is, but again, no training on the emergency aid exception either. And the only policy they have on emergency aid says that they may enter to protect life and safety. It provides no detail for how an officer is able to figure that out or determine what to do. So I'd ask your honors to find a constitutional violation, and even if you find that the law wasn't clearly established, to reverse the summary judgment on the Monell claim. Thank you, Your Honor.
Thank you for your argument. We will come down we'll come down and greet counsel, and then we'll proceed to our next case. May be seated. We'll move to our next case, 25-1669. We'll hear from Petitioner's Counsel when you're ready.
Morning, Your Honor. May it please the Court, I'm Joseph B. Cully, and I'm representing the petitioner, Sligo Creek Center. So there are two intersecting issues in this case, the merits of the Secretary's decision, but also how much of the fact-finding that supports that determination should be made by a jury. So as to the role of the jury, the constitutional principle seems pretty clear. Trust the jury. That's been the centerpiece of Anglo-American jurisprudence since the 11th century. In this case, a jury could have found that Sligo Creek Center correctly interpreted and applied its TB policy in light of the governing clinical and regulatory standards of care. That finding of fact would have directly undermined the Secretary's Appeals Board's reasoning and result. So in that sense, Jarchese actually exposes the constitutional flaw in the Secretary's internal review process. Non-independent judges, no discovery, presumptions of noncompliance, backward burdens of proof, escrow of civil money penalty, you wait 10 years, all the rest. So here, the appeals board obviously thought there was some kind of material fact issue. They purported to interpret Sligo's TV policy to find implied obligation.
Okay,
Can I ask? Oh.
Go ahead.
Yeah.
I'd like to ask about, the Supreme Court has set up an inquiry that asks about two things: the remedy
And the right,
and the cause of action, right?
correct.
And the government agrees if we were in an Article III court, this would be a jury question. But the question is, can the executive do this without an Article III court?
Correct.
What is your position on whether an Article III court is necessary for anything short of a civil monetary penalty? Or I guess civil monetary penalty might be the shortest penalty. Could the secretary withdraw Medicare funding without going through an Article III court? Could the secretary withhold funds or appoint substitute administrators for a time without an Article III court? What is your
Right.
position on that?
I don't think we need to go there for this case.
Because the answer is obviously yes, right?
But the answer is obviously yes. That's right.
So does it
Because-
all, so your position hinges entirely on the remedy, the penalty, that it's a penalty, it's a civil monetary penalty, and the secretary can do other things but can't do the penalty because that is like a common law
Well,
cause of action?
In this case, both prongs. The cause of action has to do with standards of clinical care, clearly a common law issue, goes back, long time, and the remedy. So in this case, we had hit the bullseye on both of the issues Jarchese really seems to clear up from a lot of the
And that's
confusion.
exactly what I'm trying to figure
Yeah.
out is, so say I agreed with your characterization that this is about a standard of care. Like, this is just like a medical negligence lawsuit. I'm not sure I believe that, but say I do.
Not
Could the
just
secretary, say, I want an ALJ to decide that this was medical negligence, and so we're going to withhold funds? Could the executive do that without involving an Article III court?
Yes. They could impose a denial of payment for new admissions.
So it's not the cause of
Yes.
action, really, that's
It's-
doing the work. It's the penalty that's doing the work.
It's combined,
You have
yes.
to have both.
Yes,
right?
you have to have both. And I think Jarchese clears up a lot of the confusion, or the inconsistency anyway, in a lot of the previous cases that talk about one or the other. For Jarchese, again, it's not 100% crystal clear, but Jarchese makes pretty clear that it has to be both.
Well, I think we're talking about maintaining an infection control program. What's in question here? Is there a specific breed of common law tort you believe this cause of action is analogous to? Maintaining an infection control program. What fraud tort or what tort out there is it?
Well, the notion of civil liability for allowing an infection or not stopping an infection or whatever, I mean, the personal injury cases based on that theory go back forever and ever. I mean, plus add in the public health aspects of tuberculosis control, which again have been a public health, something that local government has been responsible for hundreds of years in this
But do
country.
you agree that you could have been penalized even if there were no residents suffered any injury? You can be under the statute?
That's a long, involved answer, but the short answer is the Secretary's Appeal Board in recent years has said that in order to penalize and impose an immediate jeopardy penalty, which is the enhanced civil money penalty, et cetera, there has to be actual harm or plausible likelihood of harm. So
But the statute doesn't say that, right? Statute and regulations, I thought it had a graduated penalty system, and if someone's actually harmed,
That's worse.
it's worse. Like, you have to withdraw funds, right? Because there's a provision about if a death occurs, you definitely can't get a reduced penalty if someone's harmed.
There are grids and all that sort of thing, but they are not regulatory. They're all in informal manuals and so forth.
Well, I'm
And
curious
again,
about, to Judge Floyd's question,
Yeah.
what's your best example in the statutes or the regulations where the Congress or the agency adopted a common law standard, a common law tort standard?
This very case. If
But
you
like
look-
in the statutes or the regs, not, I know
In the-
in the opinions, they used words like standard of care, but I didn't see that in the regs or the statutes, but I may have missed it.
Well, the Supreme Court, as recently as Tavelsky, and I think co-counsel is going to talk about this, talks about this particular statute imposing clinical standards of care, right? And it's clear, if you look at, you can go all the way back to the legislative history and why they adopted this statute the way they did. It was based on an Institute of Medicine report. Congress didn't trust the Reagan administration to do what they said, so they made the statute extremely detailed. And it tracks almost provision by provision the clinical standards that are set or recommended in this Institute of Medicine report back in 1983 or 84, whenever it was, right? And just issue by issue by issue. Now, there are some provisions of the statute and regulations, and an example might be physical plant standards that are not clinical standards of care, that are based on traditional standards of care. But the infection control one is the perfect example because it doesn't include any standards itself. It specifically says you have to adopt and implement accepted standards promulgated by somebody else, such as the CDC or state health departments. It specifically refers the facility in the statute and in the regulations and in the interpretive guidelines back to clinical standards that are adopted by somebody else.
Well, my question before where it is now, put a name on the tort that you claim you have in this case.
The underlying standard would be a traditional failure to meet a standard of care, personal injury type, failure to meet a standard of care.
And you agree that any traditional tort that I can think of, someone would actually have to be injured, right? There's no such thing as a tort of creating a risk of harm to people that doesn't materialize. That is not, there's no traditional tort that looks like that.
Well, I'm not sure that we have
Name
to,
one.
Yeah, I'm not sure we have to go that far
Name
here.
name a single common law tort that does not require an actual injury to an actual person. That is based purely on what you did was risky, therefore you have torted them.
Can't come up with one right off the bat, but, right, there are some distinctions in some of the Supreme Court cases. Again, whether they survive Jarchese or not, I don't know.
Well, let me ask you about the question I was hoping to ask earlier about Jarchese.
Yeah.
I'm a little confused about your position. Do you believe there is a public rights exception after Jarchese or not?
If there is.
No.
Really
Not asking you if there is. I'm asking, do you believe there is?
I don't think there is. I agree with
Okay,
Justice Gorsuch.
so now I've looked at your opening brief. Where in your opening brief does it ever say that?
Does it ever say there is
Does it ever
not?
advance an argument that Jarchese supersedes the public rights exception? I know the amicus basically says it. Where does your opening brief say, after Jarchese, there is no public rights exception?
Well, I didn't say it in the brief because I don't think.
Oh, okay, so, and you know that under this court's repeated statements, arguments that are not in your opening brief are waived.
Well, I didn't think we needed to say it directly because we didn't think we need to, I don't think we need to get there to
I
win
understand.
this
No, I understand.
case.
And you can win this case without us saying this, but.
Right.
But now you're saying if we don't, now you're saying if we don't agree with you on your initial case, you should do this other thing, but this other thing is nowhere in our opening brief and we're the petitioner.
No, I mean, I'm answering your question, right? I
Okay,
don't
so you agree
think-
that for purposes of this case.
I don't
you
think
agree-
we- I don't think we need to go down that
not
path.
that. You agree that you said we don't have to get there, we didn't do it. You agree that for purposes of this case, we must decide this case on the assumption there is a public rights exception. That we can't say there isn't one because you as the petitioner never argued that ever.
I can buy that. Even if there is a public rights exception, I would say this case is not it, because in
So
this
why is
case,
the Third Circuit
government-
wrong?
Pardon?
Once I assume there is some public rights, some non-zero public rights exception, why is the Third Circuit wrong?
Because in this case, the government is not giving us something, the government is taking something away, and that's a classic penalty, right? We are just a contractor to the government. They are not giving us a benefit, they're giving the resident the benefit, they're giving the beneficiary.
Exalta is a penalty too.
I'm sorry?
Exalta, the Third Circuit case, I'm probably saying it wrong, but the Third Circuit decision that I just asked you, why is it wrong? That case involved a penalty too.
In that case, though, there was not even a hint of an underlying cause of action that, as the Supreme Court says, brought common law soil with it. That was entirely regulatory in the nature of like a building code. So in answer to your question earlier, there are regulations that impose essentially building codes.
Isn't it kind of negligent to ship a can of paint without properly sealing it up, on an aircraft? You can make an argument that that was kind of like a negligence lawsuit too.
I suppose, but I mean, the Third Circuit's kind of been both ways, because there's the Sun Valley Orchards case,
Right.
which goes exactly the opposite way on arguably analogous
Should we hold
facts.
this for Sun Valley Orchards? Supreme Court granted cert in that case.
I'm kind of wondering what the Supreme Court is going to do. They do need to clear up Jarchese, I suppose, because they've
I'll
opened a lot
tell
of
you
doors.
what they're going to do if anyone files a cert petition in this case, they're going to hold this case for the outcome in Sun Valley Orchards, right?
I would presume so, but
Yeah.
I would not presume to tell the Supreme Court what they're likely to do. But, I mean, you get the sense, and
Is your client injured if we hold it? I know that the government has their money in escrow. They get it back with interest if the government loses.
the government takes the position we get interest from the date the court says we get it back, not from the beginning. So, yes, I mean, we want the money sooner rather than later, but yes. Right.
All right, we'll
But
hear from
I'm well
the
past
applicants.
my time. I've reserved a couple of minutes. Thank you very much.
Good morning. May it please the court, my name is Mark Reagan. I'm here on behalf of Amicus Curiae, the American Healthcare Association, and the National Center for Assisted Living. I'd like to, given that there's been much conversation already about Jarchese, I'd like to speak to some of the questions that have been asked. I think it makes a lot of sense. I think that Jarchese is messy in some ways, and I think that the circuits are trying to figure it out. And the event that Justice Rushing referred to associated with the Supreme Court taking review of, or taking cert of the Sun Valley Orchards case will presumably explore whatever the scope of Jarchese was intended to be and the extent to which there is a public rights exception that still exists.
I mean, it may not. The court added a second question presented that was just about whether the statute even authorized penalties, right? So they may say nothing that
Also
helps
true.
us.
Also true. Just like the recent FCC case,
Right.
maybe we thought that would give some instruction as well, and it doesn't feel like that's necessarily going to go that route. But at least in terms of question one. But as to Justice Floyd's question about, give me an example of a tort common law theory that involves infection control. The COVID cases. All over the United States, there were COVID infection control cases brought against healthcare providers, including nursing facilities. And
So let me ask you the same question I asked your friend.
Sure.
Can you bring a tort based on COVID infection where no one actually gets COVID? No, right?
no,
There's not a single
True,
common law.
true.
Can you identify a single common law tort that doesn't require harm to someone?
no, I cannot.
Why doesn't that suggest this is not a traditional common law tort?
Because in this instance, somebody contracted active
But that's not,
tuberculosis.
sure, but that's not, that's the impetus for the action, but that's not required, is it, in any way, shape, or form?
It is required for a civil money penalty of at least the size, actual harm, or the finding of immediate jeopardy or death.
Okay, can I get a tort damages based on a finding of immediate jeopardy?
If
Name
it
a tort.
involved actual harm, at least,
Name a tort that I can get damages based on the prospect of immediate jeopardy.
if there's death associated.
No,
with
no,
it.
no, no, you said jeopardy.
Yes.
I can get tort, this is a very simple question. Name a tort where you can get damages based on the risk of immediate harm to someone when the harm has not yet materialized. Name such a tort.
The definition of immediate jeopardy involves the death of a resident.
Okay. So the answer is you can't think of it. In the response to my question, the answer is you can't think of such a tort.
The underlying definition of that.
I'm not
concept
asking
of-
about what you claim this definition means. I'm asking you about common law torts. I've asked at least 3 times, and you
Yes.
haven't named one.
Yes, in a common law negligence tort,
Oh, no, broaden it beyond negligence, any tort you want.
There needs to be a demonstrated harm and an actionable harm, which could be conceivably physical or emotional distress. Okay,
Well, let me ask you about this public-private thing a minute. One exception is where you have highly technical modern regulations that, I think the quote was, bring no common law soil with them.
yes.
In this case, would not those regulations fall under that highly regulated category and therefore stay in the public sector as a right?
I don't think they are in the least, Justice Floyd. Co-counsel referred to particular elements that don't deal with care, and if you and those particular elements, for example, physical plant, they read just like the building code regime that was present in Atlas Roofing. However, at page 15 of our amicus brief, we recite specifically to Congress's adoption of the Nursing Home Reform Act and its specific desire and intent to build the Nursing Home Reform Act around professional standards of care. And in the Talevsky case, which both sides of this case have cited to, the U.S. Supreme Court found that in the Section 1983 context involving governmentally operated facilities, therefore Section 1983 would apply, that there were private rights that beneficiaries could assert based upon the underlying provisions of the Nursing Home Reform Act. If those provisions of the Nursing Home Reform Act gave rise to a private right of action, they clearly are analogous to common law principles. That's what the court said in the Talevsky case. Recently, that's a 22-23 opinion, a 7-2 decision.
What about the fact that this is a voluntary government benefit program? Is that relevant? Does that mean, the government's argument seems to be, once you're in a voluntary government benefit program, it doesn't matter whether the government's giving you money or taking your money, new property, old property, none of that matters. What's your position?
Fundamentally, I believe it comes down to the framework of Jarchese, which is this a remedy that was designed to deter or punish? Is it a common law remedy, and is it based upon something that is similar to a common law cause of action? It is not an all or nothing proposition from the standpoint of how it's framed, and whether or not a healthcare provider chooses to participate in the program doesn't mean that for fact-finding purposes, when it has that kind of remedy applied.
There's an old case called Passavant, I believe, where the Supreme Court blessed the idea that public rights were involved with imposing duties on foreign imports. And that case also had a penalty that attached. So the duties applied to the imports, and the court said that's public rights, not private rights. And then there was a penalty for the amount by which the imports were undervalued. And the court said that's part of enforcing this entire program. That's all fine. Does that apply here? What do we do with that?
Well, it comes back to Jarchese. Jarchese didn't say that any enforcement action undertaken by the Securities and Exchange Commission would be necessarily subject to a Seventh Amendment right. It said when
But I
you
think what
have
Judge
this
Rushing is saying is that that's different, because, I mean, I guess you could say, like, no one has to sell securities. Fair, I guess you could say that. But it's at least one more move that says no one has to take money from the federal government by participating in Medicare. If you choose to do that, there are consequences to that decision. So I don't really think that Jarchese works in that regard, because it's another step forward to say no one has to sell securities. There's all kinds of ways in which the rules are different of, look, no one's forcing you to take the government's money, but when you take the government's money, there are consequences that come with taking the government's money.
Again, back to Sun Valley and what instruction it may provide us. No one required an employer to employ a holder of an H-2A visa either. But in the instance where
But
that
again, that's
input-
another step. That's still fighting the lake, that there's something different about saying if you want to participate in a government benefit program and take millions or billions of dollars from the federal government, there are strings that come with doing that are all in some ways designed to make sure the federal government is getting what it wants out of its money. That, like, I mean, it's not like there's not a gigantic problem of sort of fraud, abuse in the Medicare. I mean, everyone knows this. This is why there are massive Medicare fraud prosecutions and things like that. The government has a legitimate interest in making sure that the money it's spending is actually being spent to do the things that it actually wants that it's spent to do.
And we have no argument with that. All we're asking for is a neutral fact finder if a contracted provider sustains the type of legal remedy. But look, at the end of the day, Sun Valley Orchards may give us a view as to that scope. Right now, no one's arguing to this court that determinations of participant eligibility or even provider payment are necessarily subject to a Seventh Amendment jury trial right. All we're speaking about is when there are civil money penalties applied with a common law analogous claim. That's when this neutral fact finder should be provided. Thank you.
Thank you. We'll hear from the government.
Good morning, and may it please the court, David Peters on behalf of the United States of America. I understand counsel on the other side to have conceded several things. One, that CMS can impose other penalties for this exact same violation, including ultimately terminating the provider agreement, but also taking more intermediate steps, including stepping in, stopping payments, taking over the operation of the facility, and they can do all of that without reference to an Article III court. I also understand the other side to have now conceded that CMS can determine eligibility for beneficiaries for Medicare and to make determinations about provider agreements without reference to an Article III court. I think that gives up the game. I mean, Stern v. Marshall, the Supreme Court's decision says, even when there are mundane factual disputes that has to be, that are concerning private rights, that has to be adjudicated in Article III court. And the fact that now everyone agrees that CMS can do all these types of adjudications outside of the context of Article III confirms that this is a public rights scheme. I take the other side's argument to be that the difference, the key difference in their view, is that there is a civil monetary penalty being enforced here. And they say that, therefore, turns this into a Seventh Amendment case. But the Supreme Court has expressly rejected that argument, including in Jarkizi, where it said, when Congress assigns the enforcement of public rights to the executive, it can do so and have those public rights be enforced through administrative penalties that are assessed without a jury.
So just to clear something up again in terms of narrowing the range of dispute, I guess I read your brief, I just want to make sure, because I read your brief as conceding that absent the public rights exception, this is purely legal and would have to be in front of a jury.
That is a two-step analysis.
That step one is satisfied.
Step one is that, does this implicate the Seventh Amendment in the first instance? This is a civil monetary penalty. Toll says that civil monetary penalties are equivalent to common law remedies, and therefore they implicate the Seventh Amendment. But the Jarkizi analysis is a two-step analysis. Is the Seventh Amendment implicated? Yes, it is. Nonetheless, can this be the kind of thing that is assigned to the executive for adjudication because it concerns quintessential public rights? And this does. And the Supreme Court pointed to its decision in the Oceanic Steam Navigation case from 1909, and there, that was a scheme in which the Secretary of Commerce, through kind of a quarantine statute, could impose civil monetary penalties if someone imported individuals into the United States with infectious diseases, including, ironically, their tuberculosis.
Well, Atlas law, I think, still remains good law. I'm trying to get this public-private thing resolved in my head. And it provided that there's no Seventh Amendment right to a highly technical program. But this program's a little open-ended, and it gives the nursing homes a whole lot of discretion to do and don't do things. Is this conduct, is that opportunity under the Act still consistent with Atlas Roofing?
I think the best case law here, Atlas Roofing is still good law, at least its core holding, but I think the best case law here is the Supreme Court's decisions about public benefit programs, right? The Supreme Court, including in Jarkizi, said that public benefit programs are really at the core of the public rights scheme, and we cite examples in our brief dating back to the founding of Congress assigning to the executive the ability to make determinations about granting public.
Giving public benefits.
And I would say, Your Honor, the Union Carbide case is, that's the situation in which the Supreme Court points to Medicare reimbursement schemes, right, which is about payments to providers.
Making
and
payments
says-
from the government to individuals or
But
corporations.
the Union Carbide, so yes, Your Honor, in the historical examples that we cite are payments from the government to eligible beneficiaries, veterans, individuals who suffered damages during the Whiskey Rebellion. But I think the import of the Union Carbide case, right, is that's the case about the federal insecticide, fungicide, FIFRA case, right?
Rodenticide.
And rodenticide, thank you. And the Supreme Court said, yes, this kind of arbitration scheme that Congress had set up in that statutory provision was a public benefit, public rights scheme, even though it had limited kind of Article III review of the decisions that were going on there. And the example that it gave of a comparable public rights scheme is the Medicare provider reimbursement scheme.
Jarkissi doesn't rely on Union Carbide at all, and that means Union Carbide's still the law, right? But Jarkissi seemed to be trying to reorient the case law, and should we be at all concerned that they only cite Thomas versus Union Carbide for the principle that this is a very confusing area of law? They don't cite it for its legal analysis.
I think the key, though, Your Honor, is that in Jarkissi it said, look, we're not closing the book on what are public rights schemes, but they gave examples, historical examples, and they included public benefit schemes, right? They didn't cast doubt on Thomas. And I understand the other side to say, yes, of course it's a public rights scheme. CMS could, if it so wished, impose any number of remedies here. The only difference is this is a civil monetary penalty, and Jarkissi expressly speaks to that version of the argument by pointing to the Oceanic Steam Navigation case.
What is Jarkissi also said we need to identify, the government needs to identify a centuries-old rule that justifies the exception, right? There's a lot of tension, right? Arguably, they set up a scheme where the presumption is private rights, and the government has to identify a centuries-old rule that shows this falls within the public rights exception. What shows that for monetary penalties in the benefits context, taking, not giving?
I'm not sure Jarkissi goes that far and says categorically we're going to say, exactly what is a public right expressly.
I totally agree with you. They also seem to say there's an assumption that this is a public right unless you can prove it has a common law soil. So it's confusing.
I think several factors, all from Jarkissi, point in the same direction here, right? One, it identified public benefit programs as kind of.
But do you have this centuries old, what's the closest thing you have to that?
The examples we have are, again, from the founding situations in which Congress has assigned to the executive the authority to adjudicate individuals' eligibility for benefit programs. And we have from the 1909 decision, which is the Oceanic Steam Navigation case, but decisions after that as well in the tax context, as you said, in the kind of importation of goods context, in which the Supreme Court has upheld the imposition of a monetary penalty in the context of a public rights scheme. I don't have those two things together where we have the imposition of, but it's a little bit hard to imagine, Your Honor, that Congress sort of thought when it was, allocating limited funds to pay, veteran benefits, if someone came around and got a veteran benefit through, mistake or fraud, that they didn't think that that executive entity could then go after that and recover that money and impose a penalty for it. I mean,
Well, yeah, the government could reconceptualize this entire penalty as recouping funds, right? And then we might have an entirely different question, and it would be easier for you to make that argument. But that's not the way it's set up.
I think that the three factors are, or the three kind of decisive ones are, the historical precedent of public benefit programs being at the core of the public rights scheme, the fact that civil monetary penalties can be imposed to enforce public rights. That's, again, this Oceanic Steam Navigation case. And as kind of the question in the first part, there isn't a common law equivalent to this, right? This court has held in the Liberty Commons nursing case that we cite in our brief that there doesn't need to be showing of actual harm to establish immediate jeopardy under the Reform Act. And so, the petitioner here would have been liable even if the one resident hadn't established or developed active tuberculosis. And it's, I think, telling that CMS isn't stepping into the shoes of that individual. They're not seeking to recover damages on behalf of that individual. The penalty here is for the period in which the nursing home was not in compliance. That doesn't look like a common law claim in any way.
Can I ask you about the Third Circuit decision? I asked the other side about, does the government agree with how that decision goes about it? Do you think it's good for you?
I think Exalt is helpful, right? I think it's a slightly different scheme in that's a regulatory.
No, but the way that it conceptualizes how the public rights exception exists in this moment of admittedly uncertainty until the Supreme Court decides what they ultimately want to do, where it says, like, look, we know there's still a public rights exception. We know that this thing doesn't qualify. We know that this thing does qualify. We think that on balance, this thing looks more like the thing that qualifies than the thing that doesn't.
I think that's right. I'm not fighting that Exalt is helpful for us. I think it's the right decision. My point was only that I think this is an easier case in some ways because it's a public benefit program, and the Supreme Court specifically identified public benefit programs as kind of, again, this historical example of a public rights scheme.
So you think that if that case is right, a fortiori, you win this case?
I think that's right.
Okay.
I think it's a slightly different, the Supreme Court has said you look at each statute individually, but I do think this is an easier case than, regulation of paints that are being transported. This is kind of really at the core of what, Medicare, Social Security, Medicaid, those are kind of the classic examples of a public benefit scheme, which is what the Supreme Court pointed to as a classic example of a public rights scheme.
So just to take the one more step that seems to be your argument, all of those schemes that you just listed would be public rights, not private rights, and the government could impose any sort of penalties it wanted to in that context without involving courts.
I'm not sure I'm going to go that far. I do think those are public benefit schemes, obviously. I do think they're public rights schemes, and, to the extent that those schemes are setting conditions on the receipt of federal funds that are being used for the public benefit, then I think Congress can say to the executive, you may enforce those conditions on receipt of funds through the imposition of monetary penalties that don't need to be assessed with a jury. My hesitation only, Your Honor, is I don't think if Congress includes anything in Title 42 and labels it Medicare, the Constitution is concerned with substance here, and so I think you have to actually look at what the condition on the receipt of payment is. But this one is an infection control program to make sure that nursing homes that receive federal funds don't have, wild outbreaks of tuberculosis that threaten beneficiaries. I mean, that's an easier case, right? That's really, it makes good sense why Congress has said we don't want our money going to nursing homes that don't have processes in place to ensure the residents don't get, sick from a very deadly disease. And so is there some kind of extreme, outer limit to the kind of conditions? Maybe, but this court doesn't need to decide that, to say that this requirement is one that is clearly integral to a public rights scheme. If there are no other questions. Thank you.
Thank you for your argument. I believe both the amicus and petitioner have time on rebuttal. Is that right?
Thank you, Ron. 3 quick points. I've been racking my brain, Judge, to remember torts from all those years ago. I think there are probably a few torts that don't require actual harm. I mean, I'm thinking of like old breach of promise kind of torts under the common law, maybe pain and sufferings, bystanders, the mother who sees the accident, that kind of stuff in whatever states that still exist. So there might be some out there, okay? Second, the government seems to be taking the position that if the government pays money, we need not allow a jury to find facts no matter what it does thereafter. And I think that goes to Judge Rusher, when we were talking about the 2 prongs to Charchese, the underlying right plus the remedy, and I think they're disregarding.
But based on what the government just said, we're past the 2-prong test. We're into the public rights exception, right?
I'm not.
Like we're in like part 3 of the Charchese opinion, not part 2 anymore. Well, I might be getting the parts right, but there's the part where the court concludes the 2-step process. We're in 7th Amendment land, and then there's the part where they reject the public rights doctrine, right?
You can read it that way, but it's not clear that that's what they meant, which I presume is why they're taking the next case to clarify that. I mean, it is a little murky, to say the least, okay? But because they do focus so much on the penalty part, on the civil money penalty part, and that seems to be what's driving it, whether or not that's what they really meant. And I think that's the point I would come back to, is I think the government's ignoring that part of Charchese which is the court's really focused on the civil money penalty part, rather than the money being paid by the government part. So, all right.
Can I just ask you one additional clarification in terms of the things you agreed we could do without entering Seventh Amendment land? Could the government say, we've concluded based on your past violations that we should fine you $4,000, but the way we're going to do that is not we're going to make you pay us $4,000. We're just going to withhold the next $4,000 we otherwise would have given you. Do you think there's a Seventh Amendment jury trial right then?
I'm going to hedge a bit. If, you know,
I think that's a hard question for you, right?
Right. Well, it's not the way the statute.
Because the instinct seems like the answer is probably obviously yes, but if it's obviously yes, how is that any different from this situation, right? Is that the dilemma?
No, because if what the Congress says is to get around Jarchese is as an alternative to civil money penalties, we're going to just call it something else. I think that doesn't get you.
But we are. We're never going to issue a judgment. We're never going to order you to pay money. We're just going to say that, you know, your next check is going to be $4,000 light.
Well, there's always going to be some appeal from that. The underlying question is who gets to decide what the material, or who makes the judgments of fact on the material facts, right? And so you're right back into that same question. If you're just calling it by a different name, you're not resolving the question who makes the factual judgment, and that's all we're talking about.
I am sure that the nursing home crowd, the lobbying crowd, and your group and the government all participate in the drafting of this legislation. If the right to an Article III relief from the penalty section, why wasn't that written in the law?
Well, I have no idea who participated in the drafting, but it was way, way, way before Jarchese or any of the public rights cases, so it was back in the 80s. So I don't think that was, frankly, something that Congress thought about at that point, which, as you know, comes up from time to time. Congress never just thought about it. Right. Finally, I know I'm past, but if I can have 10 more seconds, I do want to draw the attention back to Kaiser, which is also, Kaiser versus Wilkie, which is also a Supreme Court case that gives you some guidance here, and that is about the substance of what the government did. Right here, you know, the appeals board found implied obligations, and Kaiser pretty much says you can't do that. So you can decide this case on the merits without even worrying about Jarchese. And frankly, we would be just as happy if you did that, right? You could decide it as a Kaiser case. So with that, I give Mr. Reagan the last word. Thank you, Justice.
Justice Floyd, I don't think that there's any evidence that the nursing home industry conceded to the existing civil money penalty scheme that is present in the Nursing Home Reform Act.
I'm not saying you conceded, you could have made it easier.
But let's put it this way, time has told us and shown us that that administrative process is by no means reflective of a neutral decision maker in the least. Also, I guess one of the questions that I think remains is does something have to be a complete tort to land in common law soil? That is not necessarily dispositive of the issue. And I know much of Justice Hayden's, your questions really focused on a complete tort. And I'm not sure that that's necessarily the test. If all of the other elements of it are in fact present, except the ones that we've been engaged in debate. And last, Justice Floyd, when the Supreme Court in Jarchese spoke about the notion about what an example of a public rights statute would be, it, as you know, said it, and it was talking about Atlas roofing, it resembled a detailed building code. That's not what Congress intended to do with the Nursing Home Reform Act. It intended to set up a scheme of essentially topics that reflected priorities through which the professional standards of care would be used for that particular purpose. And at the end of the day, beneficiaries under the Medicaid Act, under the same provisions of the Nursing Home Reform Act, have private rights. It may be that it's not a three-step process. It might be two, somewhere between private rights and the public exception, or the public rights exception may be where ultimately this particular analysis is. So thank you all very much for the time, and I do appreciate it, and we very much appreciate the ability to speak to the court on behalf of the associations.
Thank you. We'll come down and greet counsel and then proceed to our last case of the morning. All right, you may be seated. We'll hear from Mr. Ruckman for Smart Energy Holdings.
Good morning, Your Honors, and may it please the Court. I'm Stephen Ruckman, and with Jasmine Sharma, I represent the appellant, Smart Energy. This is a case about an excessive punitive fine that was imposed based on a completely new statutory interpretation. Based on just 34 complaints over 16 months, a state administrative agency imposed a record-breaking $16 million penalty on our client for conduct that the agency's own personnel repeatedly said was lawful through a process that offers no jury trial right, and now claims that no federal court can say anything about it. The penalty at issue is nearly 30 times larger than any fine the Commission has ever collected in its history, and despite being described as a refund order, it includes a mandatory $6.5 million floor, regardless of how many customers actually claim a refund, with the remainder either directed to state energy assistance funds that are not related to Smart Energy, or returned to the state via state collection agency. This is not a purely remedial measure. It's remedial and penal, and punitive, and therefore the Eighth Amendment requires proportionality review.
Okay, let's start with the fuel fund. Why isn't that, at minimum, not completely forfeited and probably not invited error? I don't understand how you can propose this and then turn around and argue that means your constitutional rights were violated. You all proposed this.
Well, so there's two things to say about that, Your Honor. First is that when we proposed it, it was under duress at a time in which we were trying to seek resolution in this matter after learning about the
Sure, then
potential
argue it
substantial-
violates due process, which you haven't argued.
Well, we think that finding this case is excessive, and as you all know...
I just don't understand how you can urge that they do something and then they do it and then you turn around and say that's a major part of our argument about why our constitutional rights were violated.
Well, actually, I think the larger part of our argument about why our rights were violated is the fact that there is a $6 million floor here, and
Sure.
that must be paid out
But
whether
you
or not...
you
any
rely
federal-
on the fuel fund, and I'm asking you, why have you not absolutely given up any ability to rely on the fuel fund given that you proposed it?
We understand that we proposed it, Your Honor, but we proposed it at a time in which we felt like we were out of options, and following precedent of the Commission in which
Lots
they
of
had proposed
litigants
it.
have hard choices to make. Say criminal defendants constantly have really hard choices to make.
Absolutely, we understand, Your Honor, and we think, again, even if you were just looking at the $6.5 million floor, that is enough to find that this is a punitive measure.
Okay.
Well, I'm a little confused about your approach in this case. On the one hand, you say you're not arguing against that Maryland Supreme Court decision, but it looks like you are.
Your Honor, we, of course, think that decision was incorrectly decided, but we are not asking this panel to overturn that decision.
But yet you are. You say it's weird and it's unexpected and it's surprising and it was almost certainly wrong as a matter of Maryland law. All of which I would say, I've read Erie, I've reread Erie, I've reread Erie. None of that is in bounds for us, right?
I don't think you don't have to say anything about that decision at all. However,
Which is bizarre, considering that the entire first half of your opening brief seems devoted to convincing me that it was wrong.
well, what's important about understanding how much of an outlier that decision, that interpretation is that it goes directly to how the penalty was calculated.
But that's
Because-
if that is a federal constitutional issue at all, that is a due process problem, not an excessive fines problem.
Well, as your honors know, the excessive fines analysis is often conflated with the due process analysis. We think they're intertwined in this case. There are a number of cases that we cite in our brief, including Fessenmeyer and Maryland versus United Elections Incorporated, where they view these as together. So I think you're right, Your Honor, that there is a due process question baked into the excessive fines analysis
Which
here.
is yet another argument that you haven't made.
Well, we've made the excessive fines argument.
No, but you
very
haven't made,
strongly.
there's these Supreme Court cases, mostly from the 60s, about like, this interpretation or application of state law was so unpredictable and so out of left field that it violates the due process clause to impose it on me. But that is not an argument you've made, right?
We have made that argument in these briefs, Your Honor. That's one reason why we spend time on the MTSA, is we think it is completely
You think
out of
you
left
have
field.
preserved a lack of fair warning under the due process clause argument?
We talk about fair notice in our briefs, Your Honor. We talk about how there was a lack of fair notice in this case, and we think we have preserved that argument.
In other words, you are making a due process type argument?
We're saying that that the excessive fines analysis is interwoven with the due process analysis. We think you can look at either one, and courts have done that. Courts have looked at both together, or they've looked at either one
Let's
to
take
find
it
it.
apart. What's the due process argument?
The due process argument is the one that Judge Hayden's was just talking about, which is, did we have fair notice, in this case, of a change in interpretation? And there's many cases in which the courts have found that if a regulatee does not have fair notice of a change in interpretation that's pretty substantial, that regulatee should not be held to the penalties that flow from that changed interpretation.
So let's talk about the Eighth Amendment. What case says that the novelty of the state court's decision is relevant to the Eighth Amendment excessive fines inquiry?
There's a case called United States versus Hext, which I believe we cite in one of our briefs, in which the court found that the new interpretation of a EPA regulation was sufficiently new and not noticed to the regulatee that it did not have to pay the penalty.
Could you say the name of that case again?
Hext Celanese Corporation, Hext Celanese Corporation. That's one case. Did I answer your question, Your Honor? I feel like.
Well, I was asking what case. If that's the best case, I'll take a look at that case.
Okay, all right, great. Thank you, Your Honor. But I think it's worth emphasizing that contrary to what Eppley will have you believe, this is not a relitigation of that judgment. It is an independent federal constitutional challenge to agency action. And the constitutional claims here were not and could not have been raised in state court. Neither claim became apparent until months after the state proceedings concluded.
Why is that again?
Well, for one of them, for the excessive fine, the fine amount was not being determined until after the state proceedings ended. And for the other, Jarchese, that decision was issued after the state proceedings concluded.
Can I ask you that? Again, I've referenced criminal defendants earlier. Criminal defendants are constantly held to have forfeited issues that are based on decisions that haven't issued at the time of their trial, because we're like, yeah, you're right, the decision that says you're right hadn't issued, but there was nothing to prevent you from making the argument. And we literally constantly say criminal defense, and they're like, how was I supposed to make an Apprendi argument before Apprendi? We're like, yeah, well, I guess, but you were required to make an Apprendi argument before Apprendi. We do this to criminal defense all that. So I don't know how you can say Jarchese hadn't been decided yet, so we never possibly could have thought to say we had a Seventh Amendment jury trial right. You could have absolutely said it.
Well, actually, Your Honor, I disagree. I respectfully disagree.
No, you would have lost, but saying that you would have lost is not saying you couldn't have said it.
But we had no good faith basis to raise that argument, Your Honor.
Sure you did.
From the Maryland Code. I don't think so, Your Honor.
The Maryland Code violates the Seventh Amendment. That's the argument you're making now. The fact that the Maryland Code says you don't have a jury trial right has nothing to do with whether the Maryland Constitution gives you a jury trial right. People say that things that are authorized by the U.S. Code or the Federal Rules of Civil Procedure violate the federal Constitution literally all the time.
I don't think it's a reasonable expectation for us to have to raise that argument in a situation in which the code was clear that we had no jury trial right.
So you definitely get treated then way better than every criminal defendant?
I can't compare this to a criminal context, but I can
If a
say
criminal
that-
defendant believes that the statute he's charged with violating is unconstitutional, he darn better raise that argument, and he can't just wait for the Supreme Court to decide the case that says he's right.
What I'm saying, Your Honor, is that up until Jarchese, we were of the view that we were obliged to follow a process that had no jury trial right. It was only after Jarchese was decided that it
How
was
on
clarified.
earth does Jarchese change anything for you? Did it incorporate the Seventh Amendment against the states?
It did not incorporate the Seventh Amendment against
Right,
the
and
states.
did it change Maryland law? Isn't there a Maryland Supreme Court decision saying that Article 23 doesn't apply to administrative proceedings?
Which case is that, Your Honor?
Consumer Protection Division versus Morgan, 2005. It's
I
in
mean,
the-
we would say that what the cases that are more important are Attorney General versus Johnson and cases that flow from that.
But like, why on earth would we think that we're in a position to change Maryland law when the Maryland Supreme Court has said otherwise?
The Maryland Supreme Court has said that the state right to a jury and the federal right to a jury come from the same common law source and have the same scope. And so when the
Where does it say the second of those things?
Say that again?
Where did it say the second of those things?
Oh,
I see cases where they say it's the Maryland right like the Seventh Amendment, but where does this common law scope equivalent to, where has the Maryland Supreme Court said that?
The Maryland Supreme Court has said in Attorney General versus Johnson that the Seventh Amendment should not be obstructed, and the enjoyment of the right should not be obstructed, and that the ultimate determination of the issues of fact by jury should not be interfered with. It talks about scope in that way. And subsequent courts, including Franklin versus Mazda Motor Corporation, say that the scope of the state right is identical to the scope of the federal.
What is your best, okay, has the Maryland Supreme Court ever said that last thing you just said?
They never said those words, Your Honor.
Identical, the same as, equivalent with, any of those words?
Coextensive with, anything like that?
They've said words very similar to that. They said that the Maryland Constitution, Article 23, like the Seventh Amendment to the Constitution of the United States, requires, and then they go and talk about the scope of the right.
That's
So
like
it's very
saying,
similar.
that's like saying a motorcycle, like a bicycle, has two wheels. That isn't saying motorcycle is a bicycle.
It's not saying that, but I also don't think that that's required to make an affirmative statement in this way. And in fact, just this past fall, Justice Gorsuch, in his opinion denying cert in Thomas versus Humboldt County, talked about how surprised he was that the Seventh Amendment has not been incorporated yet. And I think it's
I'm sort of surprised that he's surprised. This feels like a pretty open and notorious issue for quite a while now.
Well, I think, Your Honor, that the point is there are no magic words here. The Maryland Supreme Court does not need to say the words in peri materia for it to view federal rulings on the scope of the jury trial right.
So
when
can I ask
when
you,
it
Len,
interprets the
so
state
if
jury
we're
trial right.
if we're diving deep into what the Maryland Supreme Court has said, can I ask you a case about a case that you don't really deal with, which is Purnell? Why isn't that basically this case? As in, at the time under Maryland law, you didn't think you had a jury trial right, then something happened to make you think you had a jury trial right, then the person says, oh, I should have had a jury trial, and the Supreme Court of Maryland says, no, that's 100% waived under Maryland law. The time to demand a jury trial was when we were gonna have a non-jury trial, and the fact that you didn't demand one at the time means gone, gone, gone. I don't understand how that case is any different than this case.
Well, in that case, there was no Supreme Court decision that clarified the scope of the right. Isn't that right, Your Honor?
Right, but that's not what they relied on was simply saying you should have raised this at the time, you didn't raise it at the time. The fact that you think you had a good reason to raise it at the time is irrelevant, it's waived now.
I understand. Again, it's our position that we had no ability to raise it at the time.
I'm sorry, I'm Bring, I think is the case I'm talking about, where there was the Purnell argument, right?
Oh,
This-
yes, okay.
I'm sorry.
No,
My
it's okay,
mistake.
I understand. No, I see the parallels, Your Honor, but I think that this case is different.
I don't see the parallels. I think that case is literally this case that I'm asking you. If we were to write an opinion saying this case is not that case, because, what do I write after the words because?
This case is not the case because the Supreme Court has changed the law in the administrative state. It's about an administrative adjudicatory proceeding, and that's a different situation than what was in that case. But, Your Honor, you don't even need to reach the jury trial issue. If you feel like, as we heard in the prior arguments, that this is an area of law that's too undecided and you're waiting for more guidance from the Supreme Court, you don't need to decide that issue. You can easily reverse on the Eighth Amendment issue alone. But it is our position.
Isn't the
that-
amount of the fine keyed to the amount that customers paid that they wouldn't have paid but for the fraud? Isn't that what the amount of the fine is set as?
Yes, and we find that to be troubling.
So it's like a 1-to-1 ratio.
I don't know the exact ratio of the customer to the fine amount, but what I do know
But that's
is
the ballpark, right? It's in the ballpark of 1-to-1.
it's in the ballpark.
Well below the statutory maximum.
It's below the statutory maximum, but it's
So what's your best precedent for that being excessive?
it's certainly not the case, Your Honor, that just because a statute sets a maximum, that any action by an agency after that can reach that maximum. That takes away the entire Constitution.
Right, but the court has told us to be highly deferential to what the legislature has done, right? So it's below the max, and it's following a 1-to-1 ratio of harm to penalty. So what is your best case for that being excessive?
We have not demonstrated, the commission has not demonstrated a harm here, Your Honor. The
Well,
commission has.
we can't, but that's old news. We can't disrupt that,
Okay,
right? The
but
state
you-
courts decided the harm and all that, and so we can't get into the facts.
But
We're
you-
looking at the fine. You told us you're not asking us to relitigate the facts that were decided in state court.
if you're looking at the fine amount, we think it's excessive based on based on the gravity of the offense, based on the fact that our client thought it was following the law at the time until this new interpretation, based on past precedent of the commission in which the maximum fine had been $561,000.
Can I ask you that? But those folks all settled, right?
Not all of them settled. I think 2 of them did settle.
But but you would agree that in the same way, like I'm thinking now when we do criminal sentencing, like defendants constantly say, the person who pleaded guilty got a way lower sentence. We're like, right. And the difference between you and them is they pleaded guilty and you didn't. And so here I would say, so I don't know why we would possibly consider it remotely relevant the amount that people who settled had to pay, because I think on the same theory of like, yeah, those people settled, and when you settle, you get a discount. So the Eighth Amendment, you know what I'm saying? That what is your precedent for the proposition that the Eighth Amendment thinks we compare cases where people settled to those where people didn't?
Okay, well, even if we look at cases where they didn't settle, Smart One Energy is an example. Smart One Energy is the highest penalty in the record before you, and you've seen the chart at Joint Appendix 22. That is a case that did not settle, and in that case, where we're talking about far more egregious conduct, the civil penalty was far, far, far lower. I mean, again, we're comparing $561,000 to nearly $16 million, of which our client is required to pay a minimum of $6.5 million, potentially none of which going to customers. So it's just a very different situation. There are plenty of other cases in the chart that you can look at, Your Honor. We actually make that distinction for your benefit to see which ones are settlements versus which ones are not. I think I'm over the time, Your Honor, so I will step down. Thank you.
Hear from Mr. Glenn.
May it please the court. My name is Colin Glynn on behalf of the Maryland Public Service Commission. Public Service Commission regulates public utilities and also retail suppliers in Maryland, among other things. In this case, Smart Energy's central goal in this litigation is to overturn a final judgment that went through both the Commission's administrative court as well as 3 levels of the Maryland state courts, and concluded finally and irrevocably that they committed extensive violations of the Maryland consumer protection laws, and that a refund of the amounts specified in the briefs explained, a refund was the appropriate remedy.
And based on everything you would have said, you just said, I would have assumed the next words out of your mouth, and so this is all claim precluded. But yet you don't argue claim preclusion. Am I right about that?
I have not argued that in this case.
Because what you just described to me sounds like claim preclusion.
I have not argued that in this case. But nonetheless, we are here on the briefs that we have filed, and on those briefs, we have argued a jury trial. There's no jury trial right that was violated. We have argued that there was no excessive fine, and we have argued that the facts that were litigated in those cases are final.
And so now, once we're outside of claim preclusion land, you agree the Maryland courts did not decide the following questions: whether the commission violated Article 23, whether the commission violated Article 25, whether the commission violated the Eighth Amendment. Did the Maryland state courts decide any of those questions?
No, they did not.
So there would be no basis of applying issue preclusion to any of those questions.
As it relates to those courts did not decide those questions, no. Nonetheless, those courts did decide the facts, and they did decide the challenges to the application of the MTSA that Smart Energy argues extensively. And those courts were never also tasked with the question of whether there should be a jury claim, a jury trial. That never came up at any time. Under Maryland law, that right was waived under the Maryland rules, although Smart Energy identifies several cases, for example, Magin, Ellerby, and Smith. None of those cases relate to the sort of issue we have here. Magin concerns a party that couldn't raise an issue. They certainly could have raised that here.
So are you abandoning your Rooker-Feldman argument? The fact that you're emphasizing that these were never brought up in state court sounds to me like you're admitting that this is certainly not an appeal from a state court deciding something.
I am not abandoning that argument, only on the
Should you?
issue of state preclusion. In terms of what Rooker-Feldman means, if their case is to say, throw out the Maryland state court decision and throw out the issues that were...
They tell us that's not. They have footnote 8 in their brief that says we're not asking you to overturn.
They do say that.
State court.
I don't...
But you argue
my
that this
argument is that's
entire
what they're
appeal,
doing.
your brief says this entire appeal, the court lacks jurisdiction because of Rooker-Feldman over the Eighth Amendment arguments, the Seventh Amendment arguments. And
Yes.
I don't follow that.
I mean, because those arguments, I mean, yes, they could have been raised in those in that case, no argument was ever raised by them about any of those issues. They
So how
could
does
have
that
raised.
make them a state court loser on those arguments?
Well, they were a state court loser on the facts of this
That's a great
case.
preclusion argument.
Might have been,
Yeah.
but
All
nonetheless.
right, I don't want to sidetrack you. I just thought maybe you were about to narrow your case, but you're not, and that's okay. We'll roll on Rooker-Feldman, and then you get to the merits.
Thank you, Judge.
Can you focus on the refund or whatever it was a bit?
Sure, what can I help
How
you?
many customers and how does that compare? I mean, give us some idea of how big or how little that fine is, or that
Sure.
actually is.
So if we turn to the excessive fines question, in this case, we had 34 customers originally complained to the commission, letting the commission know, yes, this was a problem. An investigation was then undertaken. A lot of discovery happened. There's an enormous record on this. It's not really in this record. But ultimately, findings were determined that all of Smart Energy's 32,000 customers were affected by the wrongdoing that occurred. There was pervasive violations, both as to the Maryland Telecommunications Act, Maryland Telephone Solicitations Act, and also a variety of other concerns in terms of the way that sales calls were conducted, the way they were supervised, the way that scripts were made, that there were misleading, deceptive statements as a pattern and practice of what they were doing.
So you say this is a system-wide?
That's what the Maryland Commission found, and those were the facts that the Maryland courts affirmed. And based on that finding, the commission ordered initially, before it even went to court, the commission said, yes, we have a statutory authorization to order refunds, and the Maryland Consumer Protection Act says these contracts are null and void. They are not enforceable. And therefore, the commission said, we will order the refund, which is the way we do it typically, and which is exactly what happened here, is they said, you give them back the money that they were overcharged had they not entered into that contract. So not the every dollar that they received, but the money that they overpaid by this inducement in violation of consumer protection law to then to take that contract, which was found to be null and void. And so what we have in terms of the remedy is exactly a one-to-one relationship between the amount of economic injury that these customers suffered and the amount of refund that they were ordered to pay, that Smart Energy was ordered to pay to them. Now, secondarily, there is a civil penalty amount that was ordered of $250,000. That didn't happen until after this case was filed, but I'm not sure how much they're really arguing about that. That was less than the amount they proposed originally, but that's beside the point. But the $15.97 million were numbers that Smart Energy came up with and said, and it was audited, but they produced those numbers and said, we have overcharged by $15.97 million. If you compare what they would have paid before and you say, well, how much more did we charge them? $15.97 million. And the commission said, well, that's the amount. You've told us that's the amount. Give that money back to them because all of those contracts were null and void, and you can't have overcharged them. That is the standard remedy that the statute authorized. That is the same remedy that those customers could have got if jurisdictionally, because the commission has the primary jurisdiction over this sort of claim. You have to bring that claim before the commission in terms of a violation of commission regulations. But if they had brought that in a court and it was jurisdictionally permitted, they could have gotten the same remedy out of a court. They could have filed a class action, could have filed individual actions and gotten the same remedy. And what we have in front of the commission is a proceeding that looked really mostly like that. Now, procedurally, it's a little different, but you had a body of potential claimants, you had a bunch of named claimants, and then you had the government, in the form of two different agencies, standing in as effectively class counsel and saying, we're going to prosecute this case on behalf of these plaintiffs because they're entitled to this remedy, but for most of them, it's not that much money. So they're not going to bring all those cases. But on net, 32,000 customers, it's a lot of money, and it does matter to them. They're entitled to it. So that is what we got, and that leads to the question of, is this remedial? Now, my argument is yes, it is remedial. We have some cases that they have tried to distinguish in terms of who's arguing, is the commission the agent responsible for this? But all of that gets away from the fact that these customers, they could have got this remedy from any other court. It just happened by jurisdictional happenstance that this is where they came. But The commission functions as, in this case, it was sent to an administrative law judge. The commission functions as a court, and that shouldn't change the analysis of whether or not the remedy is remedial. Like who brought the case, who agreed to prosecute it, anyone could have represented that class. It just happened that this was who it was.
If we assume that the Eighth Amendment applies, do you still prevail?
Yes. Even if it's not remedial, even if there was some punitive aspect to it, because of the proportionality, the Eighth Amendment requires grossly disproportionate as the standard. In this case, we have a number of cases cited in the briefs, but also just this is a one-to-one comparison. We know exactly how much economic injury there was. We know exactly, because they told us, Smart Energy just produced that information, and that's not even contested. We know exactly, who these customers were, and we said, yes, go forth and pay them back the money that they got. And they have argued that there are questions about the structure of the remedy in terms of what happens to unclaimed amounts. None of that was originally in this case, but they raised it on this appeal. Argument is that's just not a fair not a fair perspective on the fact that this is still damages owed to these customers, and the fact that some of them, maybe they're dead, maybe they've moved away, that shouldn't be a windfall to Smart Energy that they should then just say, oh, well, give it back to us. That's fantastic. The state has a standard role in terms of allocating abandoned property, dealing with estates. Whatever reason those customers weren't able to show up, that shouldn't transform this one-to-one economic injury remedy, whether it's remedial or not, that shouldn't transform that into a disproportionate result. The state is not trying to take that money for itself. There's questions about exactly, who should end up with that money. This was the proposal they had, and this is what the commission chose to agree with. Now, I will say, they've got some arguments about, comparative proportionality when we talk about the other cases that might exist in here. Now, the district court did look at what the other cases that were listed in the complaint. There are a handful of them. There's not a lot of facts about those cases in the complaint, and when you look at the district court's opinion, they looked at it and they said, we don't think there's a lot here. There's not an extensive comparative analysis. I'm not exactly sure what Smart Energy wants out of that, other than presumably to go to discovery and produce enormous amounts of records on every other case, and then fight about whether this case was like this other case was like this other case. But right now, what this court had below, they didn't have a lot, and our position is Smart Energy is not entitled to any more comparative proportionality analysis than what they got. Like, the court's allowed to do that analysis. I'm not arguing they're not allowed. But that they don't have a right to say, this was error, the way the court handled it below. And if you look at those other cases, they're all their own individual facts. And if you look at the cases that Smart Energy cites about proportionality, a bunch of those cases all say, yeah, comparative proportionality is really hard. And they go through the cases that are compared in those cases, and they all say, yeah, none of these cases have anything to do with this case. Maybe kind of we'll think about them. Because it's really hard, and that's, even on better facts, more clear facts than what we have here, where the complaint doesn't say much about.
I'm not so sure you thought about this coming in, but let's assume we uphold your position on the Eighth Amendment. Is there a process by which the energy company can go back to the commission and solve those problems, whether or not it's going to be achievement to the state or whatever the administrative problems about this judgment is? Is there an ability for them to go back?
When you say an ability for them to go back, like right now, I can say, although it's separate, this occurred prior to this appeal, or I guess sort of separate from this appeal. Right now, there is an open question still at the commission about exactly which other energy assistance entities will receive the unclaimed amounts and exactly what the amount of unclaimed amounts is. That's not been finalized because they've been making refunds for the past 8 months or so, something like that. And So there is ongoing, negotiations through public hearings about exactly how to handle that money and to make sure that it is properly distributed. Does that answer your question? Or?
Yeah, I was just trying to figure out if we answered the Eighth Amendment question in your favor, that there's that pot of money.
Right.
You have mentioned, and I suppose they've argued, that there's some administrative problems about it. I'm just curious as if the amount stays in place based on our ruling, what do you do with these little nitpicky problems? And you've answered the question.
All right. So yes, I think. Anything else I want to say? I will just also add, we didn't really talk about it, but on the jury trial issue, I think it's very clear that Maryland has not tied the Seventh Amendment and the Maryland jury trial rights together. They are not a motorcycle and a bicycle. They are, if you have two dogs and they're very alike and one of them dies, the other's still alive, maybe. If something happens to the Seventh Amendment, it doesn't change the Maryland jury trial rights. They could have argued in Maryland court that it should have, but they didn't. And until the Maryland Supreme Court decides otherwise, there is very clear case law. There was no jury trial violation here because there's no jury trial right. And so it is simply not for this court to reverse on that point at all. And I don't have anything else unless the court has any further questions.
All right, thank you.
Thank you very much, Your Honors. I ask that you please affirm the judgment of the district court.
Mr. Ruckman, you have some time on rebuttal.
Thank you, Your Honors. Just a few points to clarify what was just said by the Commission. First, Judge Floyd, you asked about the record in this case that led to the fine here, and it was talked about as if they found 32,000 instances of harm. That's not what they found. All that they found was that 32,000 customers called Smart Energy and chose to enroll. And on the basis of that alone, they reach the 32,000 number because that brings it within the MTSA. So that's how they get to the starting figure. They extrapolate 32,000 from 34 complaints based purely on the fact that they called in. Something that we were told 3 times in writing was not something that would subject us to the MTSA. So I just wanted to make sure that you all were aware of that part of the record. The other thing that was mentioned that flows from that is what is the economic injury here? And the Commission said that what happened in the record in this case is that Smart Energy calculated how much we had overcharged, and we reached the $15.97 million figure. That is not at all what happened. We were told to calculate what is the difference between what customers would pay with standard offer service and what they would pay with Smart Energy service. That's the number that we reached, but that says nothing about whether or not the customer wanted to be paying those rates. Plenty of people make choices about their energy and about their vehicles and other things based on whether they want to be using renewable energy. And it is entirely possible that for many of these customers, they are happy customers. They may be paying a little bit more here and there, but they wanted to have renewable energy. That was a commitment that they wanted to make. So it's not enough to say that by the fact that we calculated as we were instructed to reach that figure, that is the figure of damages. That has not been demonstrated here. The other thing I want to mention is about comparative proportionality. The Commission said that it's hard to do. It's really not hard to do in this case. We have plenty of other cases before the Commission, many involving the MPSA, but many involving the other allegations as well. And in those cases, we can see that there was far less of a penalty imposed.
So I've asked the people who helped me do such things to look into this. It appears, at least according to what I'm told, is that in your briefs, the only other cases you talk about are where people settled. So we're introducing new facts in support of your argument here today at oral argument?
No, we talk about other cases. Again, it's in the joint appendix starting at page 22.
Whoa. It is not my job to read through the entire joint appendix and see if there's anything good for you in the JA.
Absolutely. We do talk about Smart Energy in our brief, and we also talk about the fact that there's a long history here. We do the analysis in our briefs about the history of what types of cases led to what types of resolutions. So we do talk about all those past cases. And also, it bears mention that we are here today as a company that has already been complying with the penalty. We are many months into complying with the penalty. As of today, we have paid nearly $3 million in refund checks. So we're not saying that this is all hypothetical. We are in the middle of this right now. dealing with this penalty that we believe was based on a novel reading of the MTSA. I also want to just talk about the proportionality analysis in relation to Newell, which came up again in the other argument. Newell, again, establishes a statutory maxima, but that case did not establish what the proportionality analysis is, and we think it's incumbent on the district court to perform the proportionality analysis. We also think that you have the facts before you to do that analysis yourselves. And so, again, we just want to emphasize that because there is potentially a statute that has a certain fine maximum listed, that doesn't mean that that is the fine that is appropriate. And not at all. The inquiry does not end there. Those were the main points I wanted to make in my replies. Your Honor, are there other questions? And just to reiterate, again, there are three ways in which the fine here is excessive and punitive. One is that there's a floor, a $6.5 million floor, where potentially all the money could go not to smart energy customers. Two is the way in which it can be redirected. Three is which the record is replete of examples in which the commission said it wanted it to be punitive, including the fact that we still have an additional $9.4 million hanging over our head.
So unfortunately, that does raise a question for me.
Okay.
Why does it matter what the staff say if the staff aren't the adjudicators? Your briefs are sort of assert, like, I mean, let's just assume for purposes of this question that I'm accepting your premise that staff members said things like that. Why does what enforcement staff said bear on what the intent of the sort of adjudicatory body that imposed the penalty is?
Well, when you're evaluating a fine, you want to look at what aspects are punitive, and one way to find out if a fine is punitive is the rationale that's provided by the body.
But the staff isn't the body. The body is the body that issues the fine.
Absolutely, but the body that issues the fine mentioned the staff's opinions in its order.
But sure, but that's I just the analogy I'm trying to think about is like whether something is punitive for purposes of the due process clause in a civil and thus has to be punitive damages and subject to state farm. I wouldn't ask what the plaintiff's goal is in this lawsuit. I wouldn't ask what the plaintiff thinks. Plaintiffs constantly say they want compensatory damages to send a message to the defendants and show people that they can't do this. And that sounds punitive, but we don't normally ask, what does the plaintiff want?
Well, what we have in the commission order itself is language about the punitive nature of this penalty. In addition, we have language in the district court opinion in which it talks about the penalty as disgorgement, which has been established in other cases as punitive, not just wholly remedial. So I think those things do matter to the assessment of whether it's an excessive fine. And like I said earlier, the court can resolve the Eighth Amendment issue today. The record is complete from our perspective, and the commission imposed a minimum $6.5 million fine regardless of how much reaches customers, as we've said. And so we think this court can rule on that issue, and we hope it does.
Thank you. Great, thank you.
Thanks so much.
We appreciate counsel's argument. We'll come down and greet you. But first, our courtroom deputy will adjourn court for the morning.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.